Hey, happy Tuesday, everybody. Well, it's over. Oakland Bulk Terminal versus the City of Oakland. Court battle ended today as Judge Vince Chhabria issued his decision, and his decision was not one that could be described as simple yes or no way. The judge put out a 37-page, that's right, 37-page decision, and it basically, you could say, ended with the words I'm about to describe to you in one moment. Hey, welcome to Zenny62, by the way. Please subscribe. It ended with these words, and I'm about to quote them to you right now. This is the resolution applying the coal ordinance to the Oakland Bulk Operating Terminal facility is invalid because it is a breach of the development agreement. The city is therefore enjoined from relying on the resolution either to apply the ordinance to the Oakland Bulk Terminal or to restrict future coal operations at the facility. As a practical matter, this renders the coal ordinance a nullity because the only reason the city adopted it was to restrict the Oakland Bulk Terminal's operations, and Oakland Bulk Terminal is the only facility in Oakland to which it could conceivably apply. But as a strictly technical matter, there is no reason to strike down the ordinance once it has been determined that Oakland may not presently apply it to the Oakland Bulk Terminal. The city remains free, of course, to pursue future regulation of the project so long as it complies with its legal obligations, including any legitimate contractual obligations to the project developers. Because Oakland Bulk Terminal prevails on its breach of contract claim, the court enters judgment for Oakland Bulk Terminal without reaching the constitutional and statutory claims raised at summary judgment. It is so ordered. Now, I'm going to tell you something. I've known Phil since 1990. I tried to explain this to Darren Baum-Graham of the Express, but he was so tied up in, well, who's paying you? And so I asked him, hey, who's paying you? Turns out the Telegraph Media is described as a for-profit media organization. And it also turns out the East Bay Express is described as a for-profit media organization, but that's not for here. They're making some money to keep their roofs over their head, fine, whatever. My point is this, that I was trying to explain to him and to anybody who wouldn't listen that Oakland knew what the terminal was about. And the people who showed up at the Oakland Global groundbreaking, who called for jobs for the community, who were elected officials, also knew that the Oakland Bulk Terminal was to handle a number of different minerals, including, and I might add, including, and I'm going to repeat again, including coal. Now, that's been known for quite some time, okay? For the city to then turn around and basically, and I've had elected officials tell me, well, I didn't know that, and say that, it basically lied in my face. I'm not going to say names, but they lied to my face. It's criminal. And you would say, why did they do it? To save political face. That's all it was about. To save political face. It had nothing to do with any real interest in, shall we say, justice or environmental justice or anything like that. No. They wanted to jump on that bandwagon. And some of them, I believe, personally, may have found themselves on the monetary hook relationship with, among others, Tom Steyer, the man who also has this multi-million-dollar campaign to impeach Donald Trump, the President of the United States. So they take on what has been a sadly modern political approach, a position that appears just. But when you look just behind the curtain, you find out there's a money flow attached to it. And it's always, they always present themselves as if to say, yes, we're going to save the black folks in West Oakland. Failing to point out that, first of all, the vast majority of pollutants in West Oakland come because West Oakland sits at the meeting point of all of the major freeways in the San Francisco Oakland Bay Area. You have 880 coming from the Bay Bridge. You got 80 coming from the you have 80 coming north from Vallejo and points north of the Bay Area. You have 580, which cuts through Alameda County. You have 24 that feeds into 580 at the junction right there, which is in, for all practical purposes, West Oakland. What does that bring with it? Cars. What do cars bring at this juncture in our society? Air pollution. So there's always this haze around there. Oh, and then add to that the various motor activities associated with boats and shipping in the Port of Oakland, and you add up to what we have. And then that's not to mention the dust that's kicked up and other types of particulates that are moved around because of the transport of containers and other types of materials and other types of objects through the Port of Oakland. Okay? All that put together. No one also bothers to tell you that, hey, by the way, the Port of Oakland, that West Oakland is changing in such a way that a number of African Americans have moved out because it's become more expensive, Okay? No one wants to talk about that, okay? No one wants to talk about that. It's just, oh, you're hurting black folks, as if that magic statement is going to make everybody lay down, not build anything. Think of it this, what if the coal ban remained and the Oakland Bulk Terminal developers couldn't get their money to build it and they had to sell the land? Ostensibly, that land would have went to a high-dollar real estate developer who would produce more housing. In fact, that was a plan for West Oakland quite some time ago, but then couldn't find a developer with enough capacity to really make the idea of a new town in town work financially, okay? Today, it's a different story. So it comes as no surprise to me that there were a number of questionable actions done to discredit not just the developer, Phil Tagami, in this, but to put out the idea that the city never knew what the bulk terminal was going to handle. There are a lot of people who are involved in this today who, don't know at all how we got here. The Oakland Bulk Terminal is the end result of, in part, because there's a Prologis in its project on the other side of the giant, what was once the giant Oakland Army base, of the closure of the Army base. And I was on the Alameda Base Reuse Committee. I was put there by still Alameda County Supervisor, District 5, Keith Carson. It has taken, to this point, for anybody to see any kind of development there that replaced the lost jobs due to the closure of the Oakland Army Base in West Oakland. The Army base closed in 1990, and, well, unofficially 1994. This is now 2018, so think about that. You have 1994, 2004, 2014, 24 years, and counting, that property has remained undeveloped since the closure of the Army base. That's absolutely ridiculous. what's happened in that intervening span, that generation of time, is the Bay Area, always expensive, has only become more so. Institutional investor racism that once plagued Oakland, because white investors would jump over Oakland and assume that Oakland was a black town, and because it was a black town, it was undesirable. Oakland was a black town, 60% black at one point. And so they would leapfrog those investors that were coming over from San Francisco, leapfrog Oakland, and go to Contra Costa County and Walnut Creek, okay? So, excuse me. Then when Jerry Brown became mayor, and that was 1998, 99, one action that occurred because of the fact that Brown was mayor and white and well-known, a celebrity, was the end, as Oakland knew it, of institutional investor racism. Or if you look at it another way, it's okay to invest in Oakland now because, hey, it's run by a white guy. I'm serious. We had 2 black mayors. Lionel Wilson served for, I believe, 3 terms, and Elihu Harris, who served for 2. So Oakland had 5 terms of black mayors, which presided over a very powerful growth arc in Oakland's history. By the time Jerry came in, much of even what you see today in Oakland was built. What Jerry did was make it okay for moneyed white people to be in Oakland. Not that moneyed white people weren't in Oakland, but the image was flatlands are poor and black. Hill areas, even though those of us who grew up in Oakland know that's part of Oakland, people who would visit Oakland didn't associate the hills with their image of Oakland, okay? Brown, just by his existence and actions, including developing downtown, got rid of that. But in so doing, and then as governor ending redevelopment, he opened the floodgates for this rampant creation of market rate housing we see today, which happened to be fueled by the tech boom in the Bay Area. We didn't have a redevelopment component to build affordable housing, and we weren't producing jobs for people who didn't have a tech background or a familiarization with tech organizations, and so what we got is what we have now in Oakland, an enormous homeless problem. Excuse me for one moment, okay? So, in all of that, just turning on this fan because it's warm here, but in all of that, we had an available Oakland Army base land. Now remember, because when Oakland was mostly black, it was also a manufacturing town. It lost its manufacturing jobs. And if you weren't able to get a manufacturing job, you could also get jobs at the Army base, which also had facilities for, if you were a great person at welding, you get a job doing welding at the Army base, some capacity, or any number of thousands of jobs. That was gone. So the intent was to replace that job base with a job base that could hire people in Oakland who needed those jobs. But that was the intent, but again, over 24 years, it never happened. It never happened. When Phil partnered with his gentleman, the original set of gentlemen that he worked with, and which led to the eventual groundbreaking for Oakland Global. That was 2012. 2014, excuse me. Phil, well, excuse me, 2000, yeah, that was 2012. Sorry, just making sure my memory is correct here. But at any rate, Phil already started and worked on the development rights he had been acquired at the Army base. And prior to that, he'd done extensive work for the proposal. His idea was to have this gigantic terminal system that finally fulfilled Oakland, the Port of Oakland's promise of being able to take minerals from throughout the world and put them from container to ship. That was the idea. A simple idea designed to produce many thousands of jobs. I think the estimate at one point was 10,000 jobs. So that was the overarching plan. In partnering with the state of Utah and other organizations, the City of Oakland knew that this one terminal among many, in other words, let me put it this way, the whole project is multi-terminal. It's not supposed to be just one. It's presented as one because that was the initial terminal. It was supposed to be many terminals with different lines of track, okay? Different streets and roads to handle those building locations. This was the first. It's kind of like an airport, all right? And in an airport, you have different terminals. You have, say, the United Airlines terminal, the American Airlines terminal, the Southwest terminal. You get the idea. Each terminal, each building is different, right? Such is this facility. But the bottom line is the City of Oakland knew in the development agreement what it was doing. And it doesn't matter that you might have somebody that didn't read the entire development agreement, which, you know, elected officials don't read development agreements. But there's a summary that a number of people knew and signed off on that stated in black and white that the Oakland Bulk facility would handle sulfur and coal, among other minerals. Yes, coal was written out in black and white. So the only point I have ever made is the City of Oakland lied. Again, I will repeat, the City of Oakland lied. Now you would say, why the lie? And I go back to this wave of anti-coal sentiment that swept the country, and in particular the West Coast, starting in Portland and then the Bay Area. It was fueled by people like Bill McKibben out of New York and others. But when you start looking at the people involved in this type of environmental movement, it's fair to ask, with such rampant housing prices and such rampant land development speculation, are they essentially doing land clearing to make, for example, the old Oakland Army base land or property available for housing developers? That's a fair question to ask. No one answers it. When I raise the question, and I've looked around. When I raise the question, no one answers it. You get Ziploc mouths all of a sudden. I don't want to say anything. Ooh. Okay. The simple fact of the matter is that, again, the City of Oakland lied. But there's another aspect to this entire issue, in that it's not just the City of Oakland didn't tell the truth regarding what it knew, but that those jobs have not been replaced. those jobs have still not been replaced. And the people who complain about what they think the Oakland Bulk Terminal is never answer this question. If you don't want that, what kind of jobs do you want in that area for the people who need them the most? I also get no answer to that question. Consistent silence. Don't say anything. And meanwhile, the people there suffer. I'm going to say something to those of you watching this who may be idealists, silent idealists not saying anything or just learning. Look, it is wrong to use your political ideology in such a way as to gain advantage over someone else, while people who could benefit from what that other person is doing suffer as a result of your work. If we believe we are in an advanced tech society, then why can't we come up with a tech solution to this matter? No one has answered that question. I remember, it wasn't me, but someone else posted a photo of coal being transported, covered, and I retweeted it. So somebody out there got after me about that picture saying, oh, Zinni's a friend of blah, blah, blah. Yeah, I am a friend of Phil's. Been a friend for a long, long time. I don't shy away from my relationships. Okay? Like others. I got a spine. So, I knew Phil. I met Phil through David Glover. David is the executive director, was, rest in peace, the executive director of the Oakland Citizens Committee for Urban Renewal. And we were at Oakland sharing the vision. And David said, you two brothers should get together because you have a lot in common. Words to that effect. And we became friends, and at the time, I wanted to run Oakland sharing the vision. And I was interviewed by this 3-panel board. They didn't hire me. They hired a guy named Emile Durrett, who had just got his master's degree out of the Harvard Business School, the Kennedy School of Government. As much as I liked Emile, he did hire me for some work. I always felt that, and this is a side comment, the work of Oakland sharing the vision had never been realized. Still hasn't. Oakland sharing the vision started as a meeting of 500 people in Oakland in 1990, where we put on a board goals and objectives for the city. On Saturday at the Oakland Convention Center, what I call the Oakland's giant meeting room that they call a convention center. It's really not a convention center, folks. Not like it could be. Anyway, that's how Phil and I met. And then Elihu Harris, when I met Phil, Phil was working for a guy named Randy Berger. And I think Randy had, I don't want to use the wrong term, but I'll just say that Phil and Randy were about $16,000 apart on a particular issue that did not work in Phil's favor. I think that's the best way to put it. Phil used to describe himself as equity rich and cash poor because he owned a home on Park, and but that was his equity, right? Equity rich and cash poor. But there's no doubt that he was a hard worker, established relationships with council members, with investors, with real estate developers, and had a great way of carving out a piece for himself to do some work, like, for example, with respect to determining air right value and that sort of thing. You say, well, air rights are what people pay over the air for land, right? So Phil had an idea to redevelop the rotunda. Elihu Harris, in 1995, named me economic advisor to the mayor of Oakland. Gave me the run for everything from redevelopment to the Raiders. Phil and I got together. We talked about the rotunda. I gathered together as many studies as I could on the rotunda that were done by previous developers. Oakland had spent some like $30 million on the rotunda and got nothing out of redeveloping it. The rotunda was the old Liberty House of Oakland's downtown glory days of the 50s. Among other things, it had a roof above it, okay, that was painted in gold. Beautiful. Beautiful. Keep that in mind when you go to the rotunda today and you look up. So, what happened was that Phil lobbied for the project. The city would not call him back. Roy Schweier failed to return Phil's phone calls, I believe, a total of 96 times. Yeah, because Phil gave me a list of all of his call logs, not returned. Big list, 96 times. But he kept fighting. It took Phil years. We thought he was going to die of a heart attack at one point. It took him that long to finally get where he achieved, which is an approval development agreement to build the rotunda. During that effort, I took that set of studies that I talked to you about. It's about this big. I represented Mayor Harris on the Community Economic Development Agency. So I went to the morning meeting, which were always that Tuesday morning. And when the item came up on the agenda, which I put on the agenda, I started off my talk by taking this collection of studies and raising them high in the air, because they were all tied together, and letting them drop. Boom! And I said, this represents all of the studies that have been done on the rotunda, and it cost the city $30 million. And yet, we've hired outside developers, yet we will not let Mr. Tagami have an opportunity to develop the rotunda. But he was given more than an opportunity. He was given an opportunity plus $32 million in tax dollars. So yeah, made him rich. Dang it. Dang it. No, that's the way it should be. When you have someone of capacity and a person of color, you make sure that they get the money that they need to do the job that they can do. I dare anybody to visit the rotunda and tell me it's not a beautiful facility. It has stood the test of time. It is a new Oakland landmark all over again. A jewel for the city, and that's to Phil's credit. Then the city hired Phil for the Fox Theater, and he did a Buffalo job there as well. And Phil has been a friend to a number of philanthropic endeavors, nonprofits, and people. So Phil's always tried to do the right thing. He's always tried to fight the right fight. The problem is that in Oakland, there are people who, to this day, don't want you to succeed. Unfortunately, they tend to be people who themselves haven't succeeded. I'm just being honest. There's this haterism in Oakland that has existed for decades. Robert Bob, when he was city manager, he called it crab barrel mentality, because I wanted to run the Coliseum, okay? And Robert told me, he said, hey, go and talk to Claggett. Bill Claggett was the economic development director. This was as Elihu Harris was going to go out and run for what would be a failed bid for Congress. Bill at that time and I never quite aligned. So we had lunch at Max's. It didn't go well because, well, I'll tell you, I ran into Barber Bob, as I call him, Mr. Bob. I was going out of City Hall. He was coming in. He said, "Hey, how you doing?" I said, "I'm fine. I had lunch with Claggett about taking a job at economic development." And Bob said, "Well, how did it go?" And I said, "Lousy. He thinks I talk like I think I know everything." And Mr. Bob said, "You do. You're young, you're smart, you're a threat." And because Robert recognized that, I took the job, even though I was just ready to be done with the City of Oakland. I was tired, okay? Tired. So I took that job. I say all that to give you, again, an idea of what Oakland does to this day. Elected officials do it to bring you down. When they don't tell the truth at all. They just don't. They don't tell the truth. They don't deal as honest brokers. You know, someone might say, "Oh, you know, does this apply in the Raiders case?" The Raiders didn't deal as honest brokers either. Two wrongs don't make a right. It does not make the Raiders case any better regarding a possibility of a lawsuit. That's another long story. I'm trying to give you a picture of how we got to this place. Okay, that's what I'm trying to do. So let's come back to the present and how we got to this point of the judge's decision. I read to you what he said in his final order, his point number 4 of 37 pages, okay? But note, it's 37 pages. And there's some interesting points in here that are worth reading, okay? And like, here's what I'm picking out at random. The interveners defending the ordinance, the Sierra Club and San Francisco Baykeeper, this is on page 34, raise a new argument in post-trial briefing that the California Government Code section 65866, which is a part of the development agreement statute, allows the city to apply the ordinance to the Oakland Bulk Terminal even without substantial evidence in the city council record that the coal operations present a substantial danger to people in Oakland, and notwithstanding the language of section 3.4.2 of the development agreement. The development agreement statute provides the groundwork for cities and counties to give developers a measure of certainty about the legal regimes that will govern their projects by locking in the rules and regulations that are in place at the time the agreements are signed. See Mammoth Lakes Acquisition, LLC versus Town of Mammoth Lakes. Although normally California public policy prohibits local governments from contracting away their right to exercise their police power in the future, that is, the power to regulate private conduct in furtherance of the public good, the development agreement statute creates a limited exception to this rule. See Santa Margarita area residents together, specifically section 65866 of the statute says the following: unless otherwise provided by the development agreement. Note that. Rules, regulations, and official policies governing permitted uses of the land, governing density, and governing design, improvement, and constructive standards and specifications applicable to development of the property subject to a development agreement shall be those rules, regulations, and official policies in force at the time of execution of the agreement. a development agreement shall not prevent a city, county, or city and county and subsequent actions applicable to the property from applying new rules, regulations, and policies which do not conflict with those rules and regulations and policies applicable to the property as set forth herein, nor shall a development agreement prevent a city, county, or city and county from denying or conditionally approving any subsequent development project application on the basis of such existing or new rules, regulations, or policies, all right? That was the Sierra Club position. The interveners appear to make two alternative arguments based on that provision I just read to you. The first appears to be that Section 65866 allows a local government, a development agreement, to restrict its ability to apply future land use regulations to the property, but not other types of new regulations, at least so long as those other types of regulations do not conflict with land use regulations that have been locked into place. Applying this reading of Section 65866 to this case, Oakland Bulk, the interveners appear to argue that the coal ordinance is not a land use regulation, and then the coal ordinance does not conflict with any land use regulation that were frozen in place when the development agreement was signed, and therefore Oakland is permitted to apply the ordinance to the Oakland Bulk Terminal. In other words, according to the interveners, the Sierra Club, Section 65866 does not meaningfully disturb the default rule, at least with respect to non-land use regulation, that a local government may not contract away its police power. In the intervener's view, this means that the court should construe Section 342 of the development agreement, of the development agreement and its substantial evidence requirement to apply only, 1, to land use regulations, or 2, non-land use regulations that would directly conflict with locked-in land use regulations. The consequence of this would be that Section 3.4.2 would not be applied to the ordinance at all, to avoid a conclusion that Section 342 gives away more of Oakland's police power than the government code Section 65866 permits. Whatever else might be said about this argument, the problem with it in this case is that it is too inconsistent with the language of the development agreement itself. Neither Section 3.4.1, which freezes new regulations by the city, nor 3.4.2, which sets out the health and safety exception, say that the substantial evidence standard is only meant for new land use regulations. The language of the development agreement does not even distinguish between land use regulations and non-land use regulations. And the city clearly knew how to draw a distinction between categories of regulations. The development agreement demonstrates this by carving out not only health and safety exception in Section 3.4.2, but also an exception for new regulations relating to construction under Section 3.4.4. Nor do Sections 1.1 or Sections 3.4.3, which define existing city regulations and require the city to provide the developer with a compiled list volume of those regulations, limit the laws that are frozen into place to land use regulations. As if to further prove this point, the City of Oakland itself has, from the very early days, proceeded on the theory that Section 3.4.2's substantial evidence standard applies to the ordinance. This is why the contract with ESA, the city administrator's agenda reports to the city council, and the ordinance and resolution, among many other documents, all reference Section 3.4.2 of the development agreement as the governing standard. In other words, all that means is basically this. The City of Oakland was trying to have its cake and eat it too. It was trying to say, hey, look, we got this coal ordinance, but because we have it, you can't do this land use. What the court is saying is, look, you can't use an ordinance like that one to block a certain land use that is by one developer. You cannot discriminate. That's the bottom line here. If you want to look at it from if you want to have an analogy, basically it's kind of like applying a law to discriminate only against black folks. That's essentially what the court is saying that the City of Oakland was trying to do with respect to Phil. The court said, for all practical purposes, you had an agreement with Mr. Tagami and the Oakland Bulk Organization, Oakland Bulk Terminal, and you have to treat that developer with a set of regulations that apply to all, not just one. But they designed something that applied to just one. You can't do that. That's the bottom line. All right, folks, there's the skinny. Talk to you now for, I think, 41 minutes about this. Subscribe to Zinni62, and I'll be back with more.